When a husband and wife are facing the emotional and psychological turmoil of a divorce, a question must inevitably come up as to whether the parties should seek an out-of-court settlement or if they do better to take the matter to trial. This is probably the most critical question you'll face in your divorce, and there are pros and cons to each approach. If parties cannot or will not settle out of court, then the alternative is to let the family court decide. A family judge is a county judge, but unlike district judges, they only deal with matters that fall under the Texas Family Code. This judge is supposed to act with impartiality and without any preconceived ideas about your case until they've heard the evidence presented by each side. Bringing a case to court has significant risks because you must convince the judge about every aspect of your case that you're trying to get, from custody of your children to who gets a lawnmower. Most people have a skewed idea about what court is about. They think that it's a stage in which they try to portray their spouse as the worst human on earth, and therefore they should be able to get everything. You're the good guy. But the fact is that such unfocused mudslinging very rarely will sway a family judge one way or the other. Parties really need to present their case in a way that will follow strict rules of what can and can't be said, and at the same time prove the point of each case that you're trying to present. When you choose litigation, you're putting all your trust into an attorney that will present your case for the court, and that they will do the right thing. This may be the only option if settlement offers from your spouse are less than what's fair and equitable and are less than what you think a judge will give you in court. On the other hand, if the settlement offer is close enough to what you would reasonably get in court, then the cost of going to court may not be worth the difference between the settlement and what you want to get. If you're one of the very rare few couples who maintain good communication and respect through the divorce process, you may be able to settle your matter on your own and perhaps use your attorneys only in administrative capacity to help to make sure the legalities are put in place. However, in my experience, less than 1% of all divorce cases are resolved this way. Most couples lack communication or respect by the time they file for the divorce, or they lose it during the process of the divorce. For the other 99%, they lack the ability to communicate and cooperate. Under these circumstances, it may be nearly impossible to settle your case and avoid court. Fortunately, that doesn't mean that these couples are fated to be in a contested trial to end their case. In Texas, there are a whole range of procedures to help couples who can't communicate and otherwise want to settle their case. These procedures are called alternative dispute resolution. These are private meetings outside the court system which are designed to bring about a mutually agreed settlement. In divorce cases, we most commonly use a process called mediation, but there are many other procedures such as settlement conferences, mini trials, arbitration. These can be tailored to your particular needs. I believe that each client is an individual with unique needs, and so each case is also unique and will be successful or not depending on the attention to those special details. If you're facing a divorce, you should begin to think about those details now. Depending on where you are emotionally, this may be hard, but the earlier you begin to think strategically about your case, the better will be the outcome. What are your plans for the future? Will you remarry? Do you plan to have any more children? Will you purchase a house? Will you get a new job? Money is always a very important issue in considering whether to go to trial or settle. At the earliest stage, many people try to avoid attorneys altogether to save money. What these people fail to understand about settlement and negotiation, however, is that it will only work if both parties are negotiating from a position of strength. The threat of the other side winning everything at trial is what motivates people to settle before it gets to trial. The only way for you to be able to have that strength is to hire a reputable, experienced attorney who is ready and able to take that case all the way and win. Good luck with your choices. Seek out the advice and counsel of a family law attorney as early as possible and get all the facts as they apply to your particular case. If we can be of any help, please reach out to us at mydivorcefirm.com. Thank you for tuning in. I'm Sean Palmer with the Palmer Law Firm, where we may not be able to protect your heart, but we can protect your rights.